Perhaps our most overlooked First Amendment right is the freedom of expressive association. That freedom means people have the right to come together and advocate for common causes without government interference. In America, we usually feel so secure in this right that we barely notice it's there. Unfortunately, like all our rights, this freedom sometimes comes under attack from the very government which is supposed to defend it. That's happening now in California, where officials are making onerous demands of nonprofit organizations that could restrict their ability to function. The California Attorney General's office is demanding, without any compelling reason, that nonprofits fundraising in California must disclose the names and addresses of all major donors, regardless of what state they live in. At first, that might seem like some harmless bureaucratic paper shuffling, but it's much more harmful than that, because the office leaks confidential information like a sieve, exposing donors to harassment and threats. What's more, the policy flies into the face of the law established by one of the major court victories of the civil rights era. Here's how. In 1956, the NAACP, or National Association for the Advancement of Colored People, was making significant progress. The civil rights movement was winning court cases and gaining public support. As a result, pro-segregation officials in Alabama decided the NAACP had to be stopped. They claimed the NAACP had never properly registered in Alabama and ordered the group to cease all activity. When the NAACP tried to register, the officials wouldn't let it, claiming the organization wasn't eligible because of its role in the Montgomery bus boycott and other civil rights efforts. With supreme irony, the Alabama officials claimed the NAACP did irreparable damage to the civil rights of Alabamans. Then the segregationists landed what they thought was the master stroke. They said that if the NAACP ever wanted to do business in Alabama, it would have to disclose the list of its members in the state. That was something that the group couldn't do. Disclosing the names of NAACP members in Alabama would expose them to incredible harm, such as job loss, harassment, and violence. African Americans already faced violence in many southern towns. Being associated with the NAACP would only paint larger targets on their backs. In the southern states that implemented this disclosure requirement, NAACP chapters lost more than 50% of their members over a 2-year period. The NAACP legal team was led by the famous Robert L. Carter. Carter knew the NAACP couldn't hand over its membership lists. Lives were at stake, but refusing to submit the list opened the members up to government punishment. The NAACP was promptly held in contempt by an Alabama court. Moreover, the court's order was rigged in such a way that until the NAACP handed over the list, it wasn't even allowed to proceed with the case or request the restraining order on them be lifted. This situation dragged on for years, during which Alabama successfully quashed NAACP activity in the state and held back the advance of civil rights. Thankfully, the U.S. Supreme Court realized that the courts in Alabama would never give civil rights activists a fair hearing and decided to hear the case itself. The court ruled that demanding the NAACP's membership list placed an undue burden on its members' First Amendment right to expressive association for no compelling reason. Justice John Marshall Harlan II wrote the unanimous opinion, saying that there is a close nexus between the freedoms of speech and assembly. Going on to detail how forced disclosure harmed African American citizens, Justice Harlan went so far as to compare it to forcing people to wear armbands because of their religious or political identity. He said it made no difference whether the state was doing the actual oppression, since it was forcing people to identify themselves as targets for oppression. Thanks to the Supreme Court ruling, the NAACP resumed its work in Alabama and contributed to many major advances in the civil rights movement. The NAACP's victory is now being undermined in California. The state attorney general's regulation for nonprofits to disclose their donor lists is very similar to Alabama's directive to the NAACP. It, too, will have disastrous consequences. People today across our country are concerned about public repercussions for their private beliefs, whether from the government or from their fellow citizens. The government demanding records of charitable giving is essentially the same as demanding to know people's private beliefs and opens them to possible harassments and threats. California leaks confidential records like a sieve. The Attorney General's office uses interns, contractors, and seasonal workers to handle this private information and does not punish anyone for disclosing it. That's a big problem for those who donate to nonprofits that advocate on issues that deeply divide our society. Incredibly, California is demanding the names of all major donors of organizations that solicit California residents, regardless of where the donors live or where the charity is based. Donors in Florida or Michigan shouldn't be subjected to the possible release of their confidential information based on the whims of California. Donors will be rightly hesitant to give to support causes they believe in under such conditions. There's no good reason for California to collect this confidential information in the first place. California says it is simply regulating charitable fraud, but California has never opened or closed an investigation based on donor information, rarely used donor information in any investigation, and can easily obtain what it needs through a targeted audit or subpoena rather than a blanket disclosure rule. Requiring all nonprofits to disclose their donors automatically is as needless as it is dangerous and must be stopped. Thankfully, the Supreme Court stepped in again, this time in the case of Thomas More Law Center. If, as we hope, the court rules in favor of privacy, the legacy of NAACP versus Alabama will endure, preserving the freedom of all Americans. It's fitting that the plaintiff in this case is named after Sir Thomas More, an Englishman who was killed because the king didn't like his religious beliefs. In America, we like to think we've come a long way from when the government coerced our beliefs. In the outcome of this case, we will see if that's true.